Our next session is entitled Another Return to Work. What data issues does this bring to the workplace? And it's led by Alex Milner Smith of Lewis Silkin in London. I want to introduce Alex by saying he's the co-head of the Data and Privacy Group at Lewis Silkin, and his bio on LinkedIn indicates that he's part of the sports law group and has a varied practice encompassing many different areas of sports law, which causes me to ask a very important question, which is better, Chelsea or Arsenal?
Thanks very much, Greg. I actually don't follow football very much and only really know anything about cricket, so I'll guess Chelsea, but I hope that doesn't upset you too much, Greg. And also, thanks very much to everyone for joining. I'm very excited by this because we do have an audiovisual director. And the last time I was directed was in a play at Oxford where I fell off the stage. So hopefully this will be a little bit more successful than that. The tagline of the whole Legal HR Summit today is New Normal, New Possible, and so on. And that does extend very much into data and privacy in the workplace. Personal data that we process routinely now, or at least consider processing, would have been completely unheard of, certainly in some countries, 18 months ago. Honestly, if someone had asked me in February 2020 in the UK whether we could ask about employee office visitor or, I don't know, event visitors, if we could ask them about their vaccine status, I would have probably laughed at you, although I, of course, never laugh at clients, but I might have laughed behind my hand. But this is, of course, now the new normal in some countries. And it's all in the name of protecting health or ensuring the working conditions are health and safe for your employees. And those data and health and safety desires and company desires are not always happy bedfellows. And it's interesting to think about what might become the new normal over the next 18 months or over the next 5 years. I mean, what will the next COVID-style event be that forces a very quick sea change into how we process workplace data? But it's very, very important to understand data and privacy issues in the workplace because a misuse of data and a misuse and a misunderstanding of the data and privacy laws can have serious employment issues. For instance, obviously, if you get the law wrong about asking about vaccine data and end up following a no jab, no job policy, not only might there be employment issues, there might be issues about whether you've processed personal data of your workforce lawfully and so on. Equally, we're going to talk about working from home today, which has obviously been a regular feature in the UK for the last 10 years, but has increased in the volume and the number of people working from home. If you are deciding to exit someone because of you've been monitoring their efficiency or their productivity from home, if you haven't got the data and privacy issues correct, you're going to struggle to actually effect a valid termination of someone for whatever you may have uncovered through your, no doubt, very limited and proportionate monitoring, but we'll talk about that in a second. Today, we're going to talk about a few different issues. First, Guillaume from France is going to kick us off with a session on vaccine data, including asking workers about their vaccine status and what we as employers and engagers do with that data. That's probably the hottest topic that we as Lewis Silkin are dealing with at the moment from a data and workplace perspective. We probably talk to 10, 15, 30 clients a week on that particular issue. Tiffany from the US is then going to take us through how working from home has changed and how there's more monitoring over the last 18 months, more system changes and so on. Marco from Italy is then going to take the role that I seemingly always give Marco from Italy, but the more philosophical role. And he's going to give us a more philosophical take on the shift over the last 18 months from work life and personal life to perhaps just life. And some of the data implications of where that blurring of the boundaries between work life and private life, where the risk lies for us as HR and privacy professionals. David from Mexico is then going to lead a mini session on security and data loss prevention. We're certainly seeing more activity in this space in the UK, cease and desist letters and so on. So delighted to hear from David. And then we're going to finish off, last but not least, never least, having spoken with Jessica many, many times, always enjoy it. But Jessica from Germany is going to just talk about some of the co-determination issues and the union issues that the new normal in terms of processing new types of personal data have brought up. Maybe I'll be a Pollyanna optimist and suggest that Jessica is going to say that all the unions in Germany are very happy about this new model, but I fear not. And it's just useful to understand that second part of the workplace. It's not just private workplaces. You need to think about European Works Councils and unions and so on. Just in terms of my role, I'm going to guide us through and act as a compare, as it were, a very poor compare. But I will chip in from time to time with the UK position where relevant. And we've also got Nir here from Israel, who was a late addition, so I haven't given him his own section, but he will be chipping in occasionally with the Israeli position, which we thought was very interesting because Israel is perhaps a canary country, as it were, in that they're potentially facing some issues probably 3 or 4 or 5 or 6 months ahead of us, certainly in the UK and other countries. So it's very useful to see, almost look into the future, perhaps by talking to Nir, not that he's a fortune teller, but for instance, in Israel, they're miles ahead of third shot booster vaccines. And what does that mean in terms of the workplace and so on? Please do ask questions all the way through. I will try to look at them in the chat and get to as many as I can and try to put them around the panelists just so they can get a different voice than mine. Equally, we're going to start with a small poll that I know will appear. The answers will appear in about 3 or 4 minutes. As I understand it, to participate in the poll, use the QR code or click on the link below, a link that I cannot see. There it is. Okay. Now, the questions that you should see are, I'll have to remind myself of them, drafted them so long ago. How many of you have asked their workers to disclose vaccine status? How many are making double vaccination a condition of office entry? How many have put in place new working from home technology over the last 18 months? And does that technology include data loss, enhanced data loss prevention and monitoring software? So love to see those answers. Depends on the audience, of course. If we're all in the US, or we're all in the UK, or we're all in Canada and Mexico, perhaps it would be probably 100% for asking vaccine data and demanding double vax for the office. But as we have so many different countries participating in this subject, I'd love to see what the general, in inverted commas, world position is. I will now, without further ado, hand over to Guillaume, who's going to kick us off first with a session on vaccine data and what can we or what can we not do with it in France. Hi, Guillaume.
Yeah. Thank you, Alexander. So I think that I perfectly agree with you, and it's 1 year ago, or 11 months ago, it would have been a very strange question about asking employees to prove their vaccination status. But now I think it has become a very common question, and there are clearly not a single answer in all countries, including in the EU, which can be quite strange because we all think that we all apply the GDPR and we should have all apply because we apply the same rules. We should all apply the same principles. And the outcome of the discussions that we have had between the member firms is that we don't have a single approach in all EU countries. And France is probably one of the countries which has an approach which is more strict than in other EU countries and, of course, in other countries in the world. So in the EU, obviously, we are regulated by the GDPR. So I think it's helpful to try to remind what the GDPR provides for. So you probably know that the Article 5 of the GDPR sets general principle relating to the processing of personal data. It states that personal data must be processed lawfully, fairly, in a transparent manner with the employees. One thing which is very important, data must be collected for specified, explicit, and legitimate purposes. And this is probably one of the main issues. And thirdly, the data must be processed, which are processed must be relevant and limited to what is strictly necessary in relation to the purposes. So the principle of data minimization. And this is also something that is clearly scrutinized by the data protection authorities in relation to the vaccination status. So with regard to the purpose of the data processing, the GDPR sets a list of lawful reasons for which any person, and especially the employer, can collect and process personal data. But in addition to these general principles, the GDPR states that health data merit higher protection than usual personal data. Especially the health data cannot be collected and processed unless one of the legal exemptions applies. And with respect to vaccination data, we can think about two legal exemptions which may apply depending on the position of the country and the relevant data protection authorities. First, it could be necessary to process employee health data if it is necessary to carry out the obligation of the employer. So we think, of course, of the obligation which exists in most of the countries, the obligation for the employer to ensure the workers' health and safety. We can also think about another lawful reasons, which is the fact that when the processing is necessary for reasons of substantial public interest, and when it is based on union or member state law, and when it is proportionate, then health data can be processed. We can see with these two main reasons that there are a lot of margin in the interpretation that we can give, especially with respect to the second one, substantial public interest, which should be proportionate. And based on these provisions, the governments and the data protection authorities have taken very different approaches in response to these questions. Some data protection authorities like the ICO in the UK, and Alexander, correct me if I'm wrong, of course, consider that the collection of vaccine status can be considered necessary and relevant, whereas other data protection authorities, especially in France or in Ireland, consider that it's not a valid basis especially because it's not proportionate. So, for instance, the French TPA considers that there is, with the vaccination status, and especially when the government mandates mandatory vaccination, that it's an interference with the employee's freedom to access any place, and that this limit not only must be justified by a reason of public interest, but it must be necessary and proportionate. And here the French data protection authorities, followed by the French government, has adopted a strict approach. And a law has been voted in France at the beginning of August. We can say that it's quite a balanced approach, because the law of the 5th of August requires the submission of the COVID pass in certain places which are listed in the law, restaurants, bars, shopping malls, healthcare facilities, seminars, trade shows, and including also flights and train. So the obligation to submit the COVID pass, and also in other cases for persons who are working in healthcare facilities and for healthcare professionals, mandatory vaccination. The debate before the French Parliament has been quite tense, and the outcome of these discussions, and after also the opinion given by the French Data Protection Authority, is that the law considers that it's mandatory to submit the COVID pass in certain places, which are clearly listed in the law. It is also it also mandates vaccination for healthcare facilities and healthcare professionals, but no similar requirement exists in other places, and especially if you are a regular employer, of course not an healthcare employer, not a restaurant, not a bar, but if you are a company which has another type of activities, on the reverse, it is strictly forbidden to check, to ask the employees to submit the COVID pass or to ask your employees to be vaccinated. And because there were a fear that some employers would try to ask their employees to be vaccinated or to submit the COVID pass, because it would be easy, because we are all used to submit the health pass when we want to go to the restaurant. So why not when we want to access the building of our company? But in order to prevent employers from having this idea to request employees to present the COVID pass or to mandate vaccination, the law provides that any infringement to the obligation to do this prohibition is punishable by 1 year imprisonment and 45,000 euros fine. So not only it is forbidden, but it's also very highly sanctioned by the law. On the reverse, in countries where collecting vaccination status is admitted, I think that we should be cautious about two very important things. First, but probably my colleague will comment. First, the obligation to carry out a data protection impact assessment, because it's still mandatory, and also to comply with the other general principle of the GDPR in terms of information of the data subject, data minimization, limitation of the retention period, and so on. And lastly, the employer must be cautious about potential discrimination, and especially in countries, I think, Alexander, again, correct me if I'm wrong, in the UK, where you may have the possibility to dismiss an employee if he would not comply with the obligation to provide his vaccine status. Thank you.
Thanks very much, Gwyn. That's very interesting. And yeah, you broadly got the UK position correct. So I think I'm, as always, redundant, and I don't know. I was super impressed by people's knowledge of the UK law, but I am always fascinated by France, having visited France a few times in the last month or so, and had to present my pass sanitaire at various places, and then working from some offices on Friday and not having to present it. It's quite strange from a UK perspective to get our heads around, although I understand the logic. And in fact, we're just going to move over to Tiffany from the US just to hear a minute or so on what is, I don't want to preempt anything, but a very different model in the US. And then we'll go on to Nia after that as well. But Tiffany.
Yes, thank you, Alex. Thank you, everyone, for joining us today. From the U.S. perspective, we're a little bit still in a state of flux. The federal laws that would normally, you would think, come into play to provide some privacy and confidentiality for the vaccination and testing and symptoms have kind of been thrown out. Because the EEOC has said employers can ask for vaccination status proof, see test results, and they have to hold on to that data and keep it confidential and put it in a separate medical file for that employee. But the EEOC guidance is a little bit consistent, because on one side of their mouth they're saying we recognize privacy, but the other side they're saying, but you have to disclose it. And so our federal laws, HIPAA, and the California Consumer Privacy Act doesn't really seem to come into play or stop the mandate of providing this information, at least for now. There are some privacy groups that are trying to challenge the information that's required. But in the U.S. in general right now, what's happening is the federal government has now said that all federal employees have to be vaccinated by November 22nd. And any company that contracts with the federal government and receives funding, which includes hospitals, defense contractors like Boeing, anytime you make anything for the federal government and have a contract with the federal government, they are going to send you an amendment to that contract, which says you have to have your employees vaccinated by December 8th. And then finally, the federal government has said that employers with 100 employees or more are going to have to mandate that their employees either be vaccinated or be subject to weekly testing. The Department of OSHA is going to issue regulations on that, so we don't know all the details yet, but I've heard it's supposed to be by the end of this month, September. Other people are saying no, it'll probably be an additional month, but it's expected once it's issued, it will go into effect immediately. So we are recommending employers to start planning and thinking about what your vaccination policy is going to look like, how you're going to accommodate exemptions such as religious exemption and medical disability. That's it, Alex.
Thanks very much. I mean, that couldn't be more different really than the French position, with no criticism of either position. And I think I'm going to bring in Nir here simply because, as I said at the start of this session, Israel is quite a long way down the vaccination path with boosters and so on. Total vaccination, as it were. I wonder whether you've got any commentary, and I wonder what's happening. Are there any mandates for for booster shots, and what are the data issues that you come across in Israel in relation to this?
Thank you, Alex. Okay, so since it appears that I'm already living in the future, I will try not to take too much of your time. So indeed, in Israel, Israel was one of the first countries to vaccinate the population. Actually, the first vaccination campaign was already concluded in the first quarter of the year. And then the Green Pass, which is actually the proof of vaccination, was initially introduced. However, it was, and it still is applicable almost only to public places, such as restaurants, cafes, indoor sports centers, clubs, etc., and not for workplaces. I'm saying almost because, and this is a very hot update from today, as of tomorrow, employees of those workplaces which are open for the public will also be required to present the Green Pass. Take, for example, on employees of health institutions, schools, welfare institutions, restaurants, cafes, hotels. So all of these employees will be required to present a Green Pass. But this is still not applicable for employers whose place of work is not open for the public. However, unfortunately, Israelis will never miss a good dispute, especially when it comes to challenging decisions of their employers. And for this reason, we already have more than a handful of labor court rulings with respect to this matter of the Green Pass in the workplace. In all of these rulings, the labor court has basically said that in light of this unique situation, in balancing between employees' right to privacy and the employer's obligation to maintain a safe and healthy workplace, as well as other employees' right to healthy and safe workplace, it is reasonable to require employees to provide the Green Pass under the condition that the employer offers other alternatives for the Green Pass, such as provision of negative COVID-19 tests every 72 hours. It should be noted that most of the court rulings dealt with employees who were in close contact with the open public, such as preschool teachers, social workers, grocery stores employees, and security guards. However, the statements of the labor court were general in their nature, and for this reason, other employers and many of our clients have started to implement such a policy as well. I would further mention that in the only one case where the employer did not provide an alternative for the Green Pass, and this was in an office setting, the labor court ruled that it is unreasonable to require employee to provide a Green Pass without another alternative, and accordingly ruled in favor of the employee. It is also worth mentioning that 2 weeks ago, even the High Court of Justice handed down rulings about implementation of the Green Pass in public places. This was within the framework of a petition which was filed regarding this matter by a very famous Israeli singer, who is, to our complete astonishment, an anti-vaxxer. However, the High Court of Justice ruled that in light of the scope of the COVID cases in Israel, the Green Pass is a very reasonable and proportionate measure. The court further ruled that they have no intention to step into the shoes of the decision makers, which is based on professional opinions of experts. Another issue which came up recently is who should bear the costs of the tests, as they are no longer provided for free for unvaccinated individuals. In this regard, in one of the court rulings, the Labor Court has stated that the employer should not be the one who will bear these expenses. Regarding the booster, the third shot, so right now, Israel is also far ahead with the third shot. And according to a decision of the government, as of next Sunday, generally, the Green Pass will be valid only for those individuals who receive the booster shot, unless less than 6 months have lapsed from the second shot. Given that only 1/3 of the population received the booster shot, this is something which is going to be very interesting to see how employers will implement their Green Pass policy. So in conclusion, overall, the approach of the courts in Israel is that as a general rule requiring individuals to present a proof of vaccination in order to enter public places or workplaces does not give rise to discrimination against unvaccinated individuals, but rather that there are consequences to their decision not to take the vaccine. Over to you, Alexander.
Thanks very much, Nir. That is very interesting, and perhaps with the third jab point, something that we might all have to work through over the next 2 to 6 months. I would say that we could spend the next 40 minutes discussing this. I'd love to hear from everyone, frankly, on the panel about this particular area, but we do have to move on. So I hope there was a taster in that area. Sadly, I think I'll have to conclude and summarise that every country approaches it in a slightly different way, and it is quite difficult to apply a universal approach to your vaccine status policy, and indeed if you were to push on to double vax for office entry. I'm going to come to Tiffany now, just to talk about for a couple of minutes working from home and how things have changed from a data perspective in terms of monitoring that we're doing and similar issues over the last 18 months. So Tiffany.
Yes, the monitoring, most employers, especially if people are working from home, have been monitoring using certain software and applications to make sure employees are working or to check productivity. There really has not been any law specifically dealing with that. So now it's relatively unchallenged. Again, because of COVID, I think a lot of privacy rights have been infringed upon, and it doesn't seem to be a major issue now. And the federal government doesn't, or it's probably going to be more of a state regulation as opposed to the federal government if something is rolled out.
Yeah, thanks very much. I mean, this is an issue we've talked about a lot in the UK in terms of how working from home has resulted in many clients coming to us asking, can we deploy this new technology? Can we deploy this AI system which monitors worker productivity? Can we deploy this monitoring system? And I know David in a moment is going to come and talk about we're going to talk about what some of the consequences of that are in terms of competition. But I wonder if I could just pass over to Jessica just to give a German view on this, because Jessica and I have had a number of discussions over the past 5 years, probably for as long as we've known each other, actually for 10 years, about the slight differences of approach in the UK to monitoring employees and certainly productivity, and how, say, the German courts and the German government and German states look at monitoring and so on.
Thanks, Alex. Yes, the use of monitoring software is much less common and also a difficult endeavor from a German law perspective. There's a number of reasons for that. One is that the use of any software that can be used for monitoring of employees is subject to the co-determination rights of the Works Council if the company has elected a Works Council. So it needs to be negotiated. The next thing is that the typical legal basis which is being used for monitoring, and Guillaume, you nicely explained Article 5 and Article 6, the principles and the various legal bases that can be used. Under German law, the typical legal basis which is being used in other countries, which is legitimate interest, is very, very restricted in an employment context. So this is the two legal circumstances that make it much less likely in German companies to use monitoring software. Yeah, thank you, Alex.
Thanks very much, Jessica. And I mean, I do also think we do find that, bearing in mind we at Lewis Silkin do a lot of international projects around the world, we do find that many continental European countries actually share that reticence that Jessica expresses there. So it again can, certainly with those companies that have US parented, are US parented, who want to deploy all this very exciting technology that often has been developed, as far as I can tell, with potentially offshoot businesses from the CIA and so on. I'm exaggerating slightly, but it can prove problematic to deploy worldwide, certainly in a European space. And I am genuinely, I don't get excited about very much, but I'm genuinely excited to pass over to David here from Mexico, mainly because I haven't done so much work in Mexico, but I'm very interested. What are is this an issue in Mexico in terms of working from home and the new normal in terms of how employers are monitoring their staff and so on? I mean, are there technologies that are being deployed in Mexico as they are all around the world in terms of, we've been asked to advise on keyboard stroke monitoring to check how long people take a break and whether they're going to the loo too much, and obviously in combination with all the usual monitoring that's always existed around web pages and so on.
Right. Well, I mean, obviously monitoring has been proven to be a useful practice, and it has been done in Mexico. I mean, obviously it's not only for measuring productivity, but it's also ensuring information security, defending certain rights, prevention of safety and hygiene measures, and sometimes administrative infractions. I mean, not having the employees at your regular work site may imply that they're free to, I don't know, download certain illegal software that could end up being a sanction or a fine for the company because they're using work instruments. But then again, with respect to data privacy, monitoring just perhaps crosses that privacy sphere of the employee, in particular when you get into his house or his home or her home. So obviously there's data protection regulations that we need to comply. What we have been mentioning on the proportion and what the monitoring should include, the legality and the purpose of that monitoring. In Mexico, we were far behind on home office, on telework. We just had a recently, I mean, this initial on January of this year, we have a reform that included a telework or home office, a work that allows employers to monitor on a limited basis and supervise the employees' activities. Now, there's certain particularities or certain examples that we can use. I mean, in principle, for example, there is a constitutional assumption that private communications cannot be violated. So in particular in Mexico, it is very important that emails, company emails, computers, using the cloud, et cetera, is documented that they're work instruments, and consequently we could be allowed to supervise or monitor any activity that the employee does on work instruments. So that's very important, and obviously we will need to justify the purpose of that, of us monitoring that. Employment contracts will be also a very good document to establish the mechanisms on how we're going to be monitoring our employees. Of course, as you mentioned, monitoring cannot be generalized. It cannot be at all times, and it cannot be at all spaces. And we must, in most of the cases, use some logic to it. I mean, for example, using CCTV systems, we cannot put them obviously on toilets or fitting spaces or fitting rooms, etc., etc. I mean, it needs to be on proper spaces. So I mean, even though that Mexico does not have like a law that regulates covered monitoring, there has been, our clients have been using the practical recommendations of protection of workers' personal data that was issued by the International Labor Organization that gives you two hypotheses to be monitoring employees. One, if your local or your national legislation provides for that, or number two, if there's a suspicion or reasonable grounds for either a criminal activity or a serious wrongdoing from the employee. So that's when you don't need a consent from the employee to be monitoring them, or you don't have to be very specific on why you're monitoring the employee specifically for those two hypotheses that I mentioned. And as probably we have explained, this is something that would be similar to other legislations. Any use of software, any use of monitoring devices should also follow the principles of proportionality, suitability, and minimum intervention by the employers on the employee's life. So that's for Mexico.
Thanks very much, David. I would add to that, a lot of those concepts obviously are inherent in the foundation of all data laws around the world, because they obviously come from OECD principles. I would add to that transparency as well. So just to finish off this topic, the sort of the holy trio that I always talk about with clients around any kind of workplace monitoring, and now home workplace monitoring, is really proportionality, transparency, with having a home working policy where you can set out what you should do, and David obviously mentioned also using and utilizing an employment contract to give information. But equally, one thing we love in Europe, and you know, those that have taken advice from me find me a stuck record, I think, but a DPIA, which Guillaume obviously mentioned earlier in relation to any processing of vaccine data, a data privacy impact assessment setting out why, what, how, and when you are processing data. And just having that piece of paper in your back pocket is always something useful to defend against both claims from employers and unions. And obviously Jessica's going to talk about unions later. And of course, were a regulator to get involved and look at you, at least you would be able to say, we thought about this, we're in a difficult position, here's our paperwork, and not in an ex post facto way, but you know, before the horror of a regulatory investigation happened. So I'm going to move on to Marco from Italy, who is going to, as usual, give it a wonderfully interesting philosophical take on, frankly, something that I've experienced over the last 18 months, and I'm sure we all have, the blurring of home and work life and the risks that brings and what it means from a workplace privacy perspective. Thanks, Marco.
Thanks very much, Alex, and thanks everybody. Good to kind of see you. And thanks for the philosophical, which I am not sure sits very good with lawyer, but I'm still trying to find a final answer on that. So for the moment, I'm happy to oblige to this part of the presentation. And let's start from the facts. Alex said it, it's common experience, it's common knowledge. Boundaries are blurred because they are. We were all forced by something that happened to reconsider our way of life. And if we do work goes into our way of life, and vice versa. That's something that is not escapable. The other big factor is technology. something we all, I guess, there may be very, very young attendees, hopefully, but we all remember when a video call of this magnitude was something we would have talked about at the dinner table. You know, I went in a video conference and it was wonderful. And now it's just kids saying, are you still doing your call? So everything is normal. Technology is playing a very important role, and our working time and our free time, as it was used to be called, are blurred. It's not for everybody and not for every work. Let's be very clear on that. There are works who have not suffered or enjoyed this blurring of lines, but those who have done so in a significant way. Legally, what comes into it? It's data protection, of course, because everything is data. Our work performance is data, and the private life we either share or build around work is data. Data we either give our employer or we don't, and we'll come to that in a minute. And then security, technology and monitoring laws. So broadly, those are the two legal aspects we have to take into consideration. Be mindful that data flows both ways. So private life has crept into working life. I know more about my coworkers and clients that I have ever done over the last 18 months, and employers know more about their employees. But on the other hand, employers have trusted employees at home and have trusted outside computers and have trusted networks with a number of growing data, some very crucial and strategic. So what do we do besides talking about this? Because those are all very high concepts, you know, as Spider-Man used to say, with great powers came great responsibilities, and that's true. So both employers and employees are now managing more than they did. Employees choose when to work, and then employers respond to that working time. Employers allocate work through different systems and require different reaction, and then measure performance on that basis. What can we do? And by we, I mean HR people, so yourself, and HR advisors, so ourselves. We can regulate this, which doesn't mean find a policy for everything, but means try to be clear and try to have rules that are broad but useful and take note of what happens in the workplace. The right to disconnect is there in France and has been legiferated upon and is there in the air everyone. Data protection and treatment of data have general rules that apply to the performance of working activity. So since every data we manage is a data we respond for and we're responsible for in a way, let's be aware of it and try to set the record straight from the off. I'll close this and briefly talk about risk. What are the risks? So what claims? Because in the end, we're lawyers. And it's not a perfect word, it's not a perfect job, but that's what we do. So let's not hide the fact that claims might come into it. And claims are there if data and information are not managed in a transparent way. Because, for example, retaliation claim based on action that were taken with the knowledge of personal data are increasing. Damages data and damages claims based on the handling of remote working are increasing. Why? Because of course the reaction to remote working is personal. You know, life is personal. And some people suffer more or need more guidance or need more attention, and some people suffer less. But if this new normal is not managed in a straightforward way, then those who suffer might come knocking, and then burden of proofs and all those lawyerly things come into play. And with this, I'm fully aware that it is just food for thought, but that's what philosophers do. So for a second, let me step into those shoes. I thank you for your attention, and I pass it to Alex again.
Thank you very much, Mark. Well, I think a lot of food for thought and very interesting. Just conscious of time, I'm just going to, you mentioned there the right to disconnect in France. I wondered if Guillaume just give us 1 minute, 60 seconds on how that works. I probably need 60 minutes, but just give us 60 seconds because it is a fascinating concept.
Okay. Yes, I think that France has been one of the first countries implementing the right to disconnect, probably because French employees are conscious about the need to have a good work-life balance. They want to go to restaurants, to bars, they want to enjoy their family life. So there was a concern about ensuring that companies do not call the employees or send emails outside of normal working hours, even if the mere concept of normal working hours doesn't really make sense, at least in France. So the right to disconnect is not really a hot topic for us because there is an obligation. There has been an obligation for several years now to negotiate company agreements with labor unions concerning the quality of life and including the right to disconnect. Another possibility for companies, if they don't have labor unions or if they don't reach an agreement with the labor unions, is to implement a policy which would include the right to disconnect. But we could say, well, if we don't have unions, if we don't want to implement a policy, do we really have to implement the right to disconnect? And the answer is yes, at least for part of the employees, because under French law, some who have operations in France know that working time can be a huge problem in France. With major claims concerning the payment of overtime hours, and for executives or managers, what we call cadre in France, these employees can be subject to specific working time arrangements where their working time is calculated in number of days per year and not in a number of hours per week, just to avoid the fact that if an employee works 10 hours in the day or 50 hours during the week, the company would have to pay him automatically overtime hours. So these kind of arrangements can be implemented to calculate the number of the working time on the number of days per year. Of course, the problem is that if you are this kind of manager and you work 12 hours per day, it's not something that is probably very good for your health. And there is this need to protect these employees. And one of the way that the government has and the labor unions also have chosen is to establish the right to disconnect. Just to conclude, the right to disconnect is a right for the employee to not be available to answer emails or to answer the calls from his manager. Now, some companies have adopted a very strict approach. For instance, I think that Volkswagen a few years ago, they had decided to cut all the IT access after, I don't remember exactly the hour, but maybe after 7 p.m. All the access to the emails were cut so that it's not only a right for the employee to disconnect, but an obligation for the employee to disconnect. But most of the employer only implement the right for the employees to disconnect. So only the principle under which the employee cannot be sanctioned and has no obligation to answer. Thank you.
Got it. I mean, that is very interesting and very different, obviously, to many countries. I think we're slightly running out of time, but I know, Isadora, you're going to whack up the results of that poll, which I'll just give 10 seconds on, then I'll come to David. So, put in place working from home technology, 62%. That's very unsurprising. Data loss, fine. Have you asked your workers to disclose their vaccine status? 41%, very interesting. They're obviously not in France. And then are you making double vaccination a condition of office entry? 5%. I mean, that is very interesting. I must say we're receiving 90% of our queries about that, but very few people are implementing that. But obviously a very different position to the US. And David, I'm just going to come on to you probably for just a couple of minutes, if you don't mind.
Sure.
Just on security and data loss prevention, and you're seeing in Mexico an increased sort of activity in this space around cease and desist letters and people from working from home and taking client data and so on.
Right. I mean, obviously, information security has gained greater relevance now working from home, or everybody working from home. I mean, we were, as many parts of the world, shut down for probably about 6 to 7 months completely. So it did have a greater relevance. With respect to data privacy in particular, the controller of the information must consider the risk involved of losing the security or the data, the private information. He has to be sure that their security measures of the information, technology, technical, cybersecurity, et cetera, companies have implemented systems to ensure that information security breach, cybersecurity, et cetera, but it has been very helpful to train employees and obviously raise awareness and changing or promoting a cultural change on awareness on the level and the real value of that information and the levels of confidence of the staff in securing that information does not go outside just the working environment or the employment relationship. But I mean, according to the Ponemon Institute, I mean, 78% of the organizations suffer security incidents due to negligence and malicious employees. So we're still a long ways to go on cybersecurity, or at least information security, I might say. And what we have seen is that with these changes of employment, going perhaps to a competitor, and because we don't have non-competes in Mexico, or at least enforceable non-competes, we have seen a significant amount of clients asking us for cease and desist letters, because they tend to think that employees working from home were not monitored properly, and they just believe that the employees have been acquiring this confidential information that they might be using with their new employers or with the different companies that they have changed. So this is the only, not as a non-compete, but as a cease and desist letters of using confidential information, the way in which most of our clients have pressured these employees on not using this information. Of course, this will always turn out to be the burden of proof of whomever is claiming that there's a breach of confidential information, and it's still difficult to prove in Mexico that employees are using that unless there's obviously something very evident that the employees were using this information, and of course that the former employer notified the employee of that was confidential information.
Thank you very much, David. And I'll just make 2 points on that. I mean, we have seen, we always see a lot of competition activity in the UK, but we have seen a significant increase this year. And I just wonder whether people think when they're working from home, going back to the monitoring discussion that obviously Tiffany started, I think maybe sometimes people miss that we will know if you are going to steal a whole client list. What we have also seen on the other side of the coin, and David, you touched on it, is a significant increase in both human error data incidents. I won't call them data breaches, but they obviously are data breaches, but human error data breaches, simply because, I'm in the office today. Am I a bit more professional? Probably not. But it is just very different to being at home. I might have my cat on me, which is one thing I talked about with a client, and suddenly I've sent an email to the wrong person. I've sent it to David Peters rather than David in Mexico, and what I've sent him is an enormous client list. But on the other side of the coin, we have seen an enormous rise in hacking of all types, ransomware, phishing. And again, I've got my cat on me. It's very easy just to look at an external email and click on a link that I shouldn't have done. So it is sadly an unholy sort of circle of risk there for employers that they really need to get their head around. We are now 5 minutes from time, and it is with great pleasure I will now move on to Jessica, who is going to talk about co-determination and union issues, probably touching on all the things we've talked about, because they're all probably of interest to unions. And then I'll come to Tiffany after that.
Thanks, Alex. Yeah, the unions actually don't play such a big role in all of these topics. So what we do have in Germany, as I mentioned before, is the works councils. And I'm just conscious of time. I'm going to give you 4 observations. One is that the number of software has continued to increase, and all larger employers who have a works council really have a very hard time following up on co-determination, as every one of those new softwares needs to be implemented by a mutual agreement with the works council on the rules on how those data can be used. So this is certainly a difficult issue for many employers unless they are able to negotiate a mechanism which gives something like a framework, and then you just add each new software and you have a framework of rules which stays in place. So yeah, this is my first topic. Second thing is that we spoke about remote work, and there's a new legislative law which has clarified that works councils are entitled to co-determination with regard to rules on work from home. So in the beginning of COVID, we as a firm were mostly busy drafting individual agreements, and in some cases works council agreements. Now this is really a new trend, and currently we have a variety of clients in drafting those policies. The third topic is that there's the legislator has seen that there is a rise of artificial intelligence, which is going to be used in monitoring and as part of the of just other programs which are being used at the workplace. So there is now a variety of rights for the Works Council to co-determine on the use of artificial intelligence at the Works Council, at the workplace, sorry. And my fourth observation is that Works Council meetings, there was a law which was hastily passed during COVID that Works Council and also arbitration boards can meet digitally. And now, as of June, there's a slightly amended legal rule which says that works councils can continue to meet digitally. And this is what I observe at the clients as well, especially if they work from home. They don't meet in person anymore. They don't sit around a table and have a drink and discuss the topics. They meet via Teams, similar to what we and our clients do. So that's it from my side and the co-determination.
Thanks, Jessica. And I'm just going to hand over to Tiffany just for a minute, just from a US perspective on, forgive me, Jessica, for talking about unions. As you know, I'm not an expert in this area. For the union co-determination perspective in the US, whether US unions have picked up on some of these data issues that we've talked about, and whether there are any, not problems being caused, but issues being raised, shall we say.
You're mute.
I think you're on mute, Tiffany.
You're mute.
Sorry. From a U.S. perspective, if you're changing a terms of employment or terms and conditions of employment, it has to be negotiated with a trade union. And so if you're implementing vaccines or testing or requiring employees to have monitoring on their computer system, that has to be negotiated with the unions. And there are a lot of trade unions that are now challenging the federal law mandate to have public employees be vaccinated, and they probably will challenge the private employer mandate as well on the federal law mandating their employees be vaccinated. So there are a couple of cases filed and more likely to come.
And Tiffany, I mean, that'll obviously start at a local state level, but will that be expedited to a federal kind of level? Would that be a Supreme Court, worthy of a Supreme Court decision? I mean, someone being mandated that their employer is telling them, I mean, I guess if they're public employed, then it's their government, but telling them that they must be vaccinated, is that something that is worthy of the Supreme Court? I mean, and will that take so long that in 6 years' time we'll be worried about the next thing? So, I mean.
Yeah, so it for the federal employees especially, that will be a federal law issue, so that will have to be filed in federal court, and there are some processes that you could expedite it to the Supreme Court after an initial determination is made. Also, I think there are some requests to halt or put an injunction on the enforceability of that law, so they could stop it before it goes into effect.
That's very interesting. We have to watch that space. I mean, there'll be an almighty battle because obviously Biden has been so clear on basically if you're not having the vaccination, you're letting everyone down broadly, is what he said. I mean, probably I've been more elegant than Biden there, but anyway, eloquent. Listen, we're now past time. I really just want to say thank you to everyone who's listened and to all our panelists. Just in summary, the new normal has produced lots of interesting data and privacy issues in the workplace, and they aren't over. We're all going to work through all of these things, from how can we process vaccine data to no jab, no job, through to what is the new normal of working from home, because working from home is not going to disappear. It will be here forever. And I mean, I'm just very interested in Jessica's comment about artificial intelligence. Frankly, we have seen a rise in interest in artificial intelligence in terms of monitoring and data loss prevention technologies over the last 18 months. But I do think probably artificial intelligence is something that we could have another 60-minute session on, frankly, probably unrelated. Perhaps it's been expedited in terms of deployment, but it's certainly something that is very interesting.